thought I might start, and I hope people are okay with this. I thought there's a few things that might be a good start or a good return just to clear up. What I refer to is I've had the opportunity to talk with a number of you, and there is a recording about what exactly happens when a judge is leaving the court and returning, and exactly how that whole process works. And I thought that would be something relevant as well as useful for those on the call. The other area I would love to be able to cover again is this issue of how do we know that common law is dead? What are exactly the forms of law that we're dealing with? Because there is so much information still out there, especially even the judges saying that common law is operating in their courts. So I thought that would be relevant to clear that up. The other thing I'd like to do is ask for questions, if we can, in terms of people's feedback on how they're going in reading positive law. But I feel I've done a little bit of an injustice by not covering some of the other books of canon law, and especially talking about natural law as well as divine law. So I hope people on the call don't mind. But it is relevant because without discussing it, without explaining what it is, getting the full picture of what, in fact, these canons are doing, I feel we're not doing full justice. So just to quickly summarise what we've just said then is, firstly, to go back through and talk about some of these mechanics and procedures and knowledge that we've discussed in the past on exactly what judges are doing when they run out of a court. Secondly, to talk about this area of common law and how do we know that common law is being abrogated and what are the new forms of law that they're using. And also this area of asking your feedback on positive law, and just a bit of a discussion about natural law and the bigger picture of what we're really trying to achieve in the promulgation of these canons. So I hope the people on the call are okay with that. I hope you find the information useful, and I also look forward for us to be able to interact and ask and answer questions. So I'm looking at, just to let everyone know, we're looking at a maximum of 2 hours, where I really hope to cover these points in the next hour and really leave it open to a good discussion, Q&A, contributions for the second hour. So with that in mind, I'd like to get stuck into it. So the first thing I'd like to discuss tonight with you and share with you is just a little bit of a clarification and a recap on this idea of exactly what is a judge doing when they leave the court. But before we get into that, I think it's also relevant to highlight something that we need to understand from the get-go. When you read positive law, one of the things that, particularly when you come to it first off, one of the things that you'll probably immediately strike you is that the definitions that you read in positive law are, in many cases, completely different to what you will find in Black's, in Oxford Dictionary of Law, and in jurisprudence and in definitions within case law. And the reason for that, and we've said this before, but it's important to remind ourselves, the reason the law is so complex is that the Roman system, the parasites, the Khazars, the ruling system does not want people to understand the law except for very few. And in a court, there will only normally ever be one person that has any clue of the law, and that's the judge. Everyone else is supposed to be ignorant and by being ignorant are, by default, incompetent. And by being incompetent gives the judge a massive advantage in every matter brought before them. Now, this is obviously fraudulent, this is obviously evil, but this is the system. And it's why, by the way, if you've ever seen, and not everyone has seen this, you may have heard this, but when judges get elevated to higher courts, one of the most common things that will happen is that judges from the higher precinct will actually give them collectively a book. Now, it may look like an old and tattered book, but in most cases what they're in fact giving them is the key. So what happens with law and lawyers is that they spend years and years and years learning procedure and studying all kinds of definitions, and they are required to learn it, and they're required to prove that they know it. What they're learning is they're learning the rubbish and the knowledge intermingled. It's only when they get to the point of becoming a judge or a higher judge will they ever be given the keys to unlock the truth embedded in the lies. So don't ever think that judges know all the law, and certainly don't think that anyone in a court knows what the hell's going on. So, before you ever enter a court, if you haven't reversed, if you haven't responded to the summons, the demand, the notice, then under Roman law, they will have converted you into a thing. Now, we've discussed this before, but it's the first point before I get to the actual court. That is to say, if you encounter a court where the judge does have some knowledge, then they will know automatically that you have already been turned into a thing. And by that, you have no rights under maritime. They only have to leave the court, return, and they can simply say to you, if you say another word, we'll hold you in contempt, and you can go to prison for 6 months. And it's lawful under the form of law, under canon law of 1983, which is known commonly as maritime law, then they can do that because you're a thing. So when we go through and we've discussed and we talk about the importance of responding using the ecclesiastical deed poll and establish your standing, it cannot be overemphasised how important that is before you ever arrive to court. But if you happen to arrive to court and you haven't repudiated their claim of turning you into a thing by those documents, then the first form of law that you will face is the Uniform Commercial Code of 1933. That's the first form of law. And what they will present that as is common law. But of course, common law was based on things such as common law rights, writs, habeas corpus, and others, and the ability to establish your standing and be given the opportunity to establish your standing. But of course, under Uniform Commercial Code, none of those things apply. You are either an owner of property or you're not. If you don't own property, then you have absolutely no standing whatsoever in a commercial court of law. So when you arrive, and assuming that you are lucky enough to get a judge that isn't fully conversant with canon law, they may give you the opportunity to speak. Now, if you do establish your standing this way and establish that you are living, that you are the trustee of a express trust, and please, I hope no one ever goes down the road of saying that you are the trustee and beneficiary, or any of these kind of phrases that have been bandied about. You cannot be two officers of the same trust at the same time. You can, in fact, be a executor of a will and then a beneficiary, but not at the same time. So, yes, you establish your standing. You know, I am living, the flesh lives, the blood flows. I am standing here as a trustee of an express trust. I'm here to, hear the accusation. Now, if the judge, as I say, is not conversant in canon law, then they may well entertain this. And if they do, they will understand that under commercial code, if you've gone to them, or better still, if you've gone to them and said, I stand here as I said, as a trustee of a trust, not as surety to the corporate fiction, then that court knows and that judge knows that he has no contract. If you're not surety to the corporate fiction, which is represented by the birth certificate, then he has no jurisdiction. He has to establish a higher jurisdiction. Now, he does it of one of two ways. And when I've spoken before, what I've said to you is that one way they establish it is to run out of the court, literally, run out of the court without any notice. And unfortunately, in the past, this was seen as a win, almost kind of like a joke. And you would hear from people around the world that they thought this was funny. A judge leaves, I've scared off the judge. The judge is afraid, and I've won. And in many cases, the bailiffs and other members, officials of the court, play along with this ruse and even say to defendants, oh, well, you might as well leave. They want you to leave, particularly if you've shown any kind of knowledge of the law. They want you to leave. Why? Because that judge has not finished the case. The case has not been suspended. There is no advantage. What the judge is doing is about to re-establish their standing in a higher court when they return. Because when they return, you will no longer be subject to Uniform Commercial Code of 1933. You will be subject to Canon Law of 1983, or what we know as Maritime Law. Mari, sea, timeo, fear of the sea, fear of the Holy See, the laws of the Holy See. And when he returns, he will be converting you, and probably very firmly converting you into a thing. Now, one of the gambles of their courts, and they can only change the form of the court 3 times. That means they can only leave twice. There is only 3 forms of law that they have, the highest being Talmudic law now. But here's the problem. Yes, you want to establish your rights. Yes, you want to argue your case. But the odds get higher. Now, under Uniform Commercial Code, the worst thing that they will tend to do is fine you. It's commercial. It's money. All crime is commercial. So there'll be a bond, $1,000 bond or a fine. Of course, if you can't pay it, then they may add further punitive penalties on that. But that's basically what they're dealing with, bonds and generating bonds. But when that judge returns to that court, into the second form of the court, then under canon law, maritime law, the law of salvage, the salvage of things, their strength is now to order the goods to be put in the warehouse being the prison. The odds and the penalty just got higher. And the most common way that will be presented is to charge you with contempt. So you'll see it as contempt, but really what it is taking the thing, the goods, to the warehouse. Now, if you really want to gamble to the third level and you don't know what's going on, then under Talmudic law, the penalties of Noahide law are pretty, well, let's just say. I mean, the penalty of breaking a Noahide law, if you look at Wikipedia, is death. Now, I'm not saying that they're going to issue a death penalty, but it's on the table if that was what they wanted to do. So the odds get far, far worse when you want to challenge them. So it's very important that all of us understand what we're dealing with. So back to what we're saying. So you're in court. You've established that you in no way are the surety of the corporate fiction of their Sesta KV trust, evidenced by the birth certificate. You are a trustee of a separate trust. The judge knows straight away he has no jurisdiction because you're not paying surety for the injury. And whenever they write up their charges, it's always against the corporate fiction, always. So if you're not the surety, they have no one there to stand there for the fiction. So the judge will run out of the court. Now, another way they do it, and this is something that we haven't discussed before, and I want to bring it onto the table, is these 2 words, recess and adjourn. And I'm sure you've heard it, the bailiff saying, calling a brief recess, or the matter is being adjourned. Now, I want to mention this because this is when they do, in fact, give public notice to the changing of the form of the court. Unlike the judge running out and playing games in the hope that you think things are fine, and hoping, and the bailiff, in fact, in many cases encouraging you to leave the court, and by leaving the court, lose the case just when the judge has gone into a higher jurisdiction. When a bailiff, when the clerk announces that the judge is called for a brief recess, then they're giving public notice that, in fact, they are changing the form of the court. Now, what's the difference between recess and adjourn? Well, there's a huge difference, and it's important, and I hope all of you will see the difference in this call. A recess technically means a retreat, a withdrawal. In fact, a recess is one of the names for the small alcoves, chambers. When they say recess, they're withdrawing one form and returning with another form. So, and normally, whether it may appear as an announcement, it's actually an offer. So when they say we're calling for a brief recess, you have the right to say, I object to that. I don't agree with that. I don't consent with the recess. They're making an offer. They're contracting you. So if you don't object to the fact that the judge is about to go off and change the form, then the implication is you have agreed to the new form. So be very careful when someone says we are calling a brief recess. You say, no, I do not consent. Adjourn, yes. Recess, no. Now, an adjournment is when the court suspends its present form for a short time or a long time. Doesn't matter. But when the court returns, it's in the same jurisdiction. So there is no reason that a judge or a magistrate can't adjourn a matter for 5 minutes, 5 seconds, 5 days, 5 months, rather than call the word recess. If you ever hear the word recess, you are witnessing an offer to change the form to a higher jurisdiction. So I hope that clears that up. But as some of you have seen, and it has happened now more and more, there will be no announcement, and the judge will merely run out to their chambers and return sometime later. So in the example we've said that you've gone in there, UCC is the first form of law, they run away, they come back in, we're now in canon law, we're now in the law of maritime. Now, if you don't re-establish your standing, then you have no standing. And of course your standing changes in the different form. Your standing in the second form, in canon law, now relates to the type of person. So no longer is it a matter of surety for commercial debt, it is your standing as a person in regards to the Roman law. So if you don't establish that, then of course you have no standing. Now if you do establish that, in rare occasions the judge will leave for the second and last time and return, and then you'll be subject to Talmudic law. And under Talmudic law, of course, you get into the whole argument as to who the judge represents in Talmudic law and who you are in Talmudic law. Now, the worst thing you can ever be in Talmudic law is someone that holds no property rights, because under Talmudic law, a person that holds no property rights can be enslaved without any objection. In other words, they can do whatever they like to you and you have no rights whatsoever. So I just wanted to go through some of those points. I know we've discussed them before, but these are some of the tricks that they do and continue to do against us. The remedy to this is understanding positive law, and I think it's very important that we remind ourselves that the only person in the court that is ever supposed to know the law is the judge, but even then, not every judge knows the law. So don't be upset, concerned, distraught when you are reading the canons, the divine canon law, that there's a difference to what you were taught. That's deliberate. They don't want you to know the law. But hopefully as you see the tricks that they play and realize that it is all fraud, they want you to appear incompetent. The more you know, the stronger you become. The stronger you become, the less ability they have to play these games. And look, when it comes down to it, if someone stands before you as nothing more than a bully, nothing more than an enforcer, that's different than someone standing before you saying they represent the law. If people saw them purely as bullies, as tyrants, their ability to stay in power would be measured in days and weeks, not years and decades. But the fact is that they continue to use the law to hide behind the law, and that's why we need to move forward. Okay, so that's just a bit of background on some of those things. Now, did anyone want to comment on that before I talk about common law? Anyone got a comment or question before we talk about common law?
Well, Frank, it's Brian here. You mentioned standing, and that's a very, very important point.
Yes, it is.
Yeah, absolutely. Because again, as you'll be talking about the trusts and stuff like that, it's absolutely essential that the knowledge be shown in competence.
That's right. That's right. Standing is there's two elements to standing. They're the two most important. Now, people use the word standing all the time. They're standing and standing. Standing is not a matter of saying I'm a doctor, a lawyer, whatever. When someone says you're a doctor or a lawyer, the implication is competence. That's the implication, competence. Yeah? So the two elements to standing is this: competence and whether you are or you are not a holder of property. Yeah?
Yeah.
That's all there is. So if you can establish competence, most people that go to court don't hold property rights. They might think they do, they're not. They hold equity. Yeah?
That's correct.
So hopefully that's a clear point. Thanks, Brian.
Thank you, Frank.
Anyone else, just before we go into just doing a quick roundup again, just talking about common law? Anyone?
Hey, Frank. Michael Joseph here.
Hi, Michael. How are you going?
Well, thank you. I'm doing well. Yeah, I had just a comment. Part of establish, you say that if they make you an offer in commerce, then if you fall silent, then they're trying to convert you into a thing. And, well, what if you don't fall silent? What if you, go about your business of doing everything under the sun that you can think of to show that it's your express will and intent not to accept this offer?
Well, that's precisely right, Michael. Joseph, that's exactly what you need to do. And there were two elements to that. The first was that the canon law of 1983 is still fairly recent. I know it's some decades old now, but look, these judges are not geniuses. It takes time for them to be taught, and they can't just teach them straight, otherwise they'll all resign. They have to teach them almost by allegory over years and years and years, because that's how the whole law works. So there were two things I mentioned. One was the fact that under the system, when they send you a summons, a demand, a warrant, or anything like that, the actual instrument, by definition, is converting you into a thing if it is unrebutted. Yeah?
Well, I'm just going to posit that the thing that it's creating you in, now, since they're capitalizing that offer, and they capitalize all express trusts, effectively, if you remain silent, you either are accepting the fiduciary or you're, let's say, the office of fiduciary. So in effect, you're leaving your status, which is man, and you're entering an office, which is a thing.
Well, the role that you are partly correct, Michael Joseph, in that you are in fact accepting a commercial position if you don't rebut. The commercial position, there's two things that you're doing. I mentioned thing, but let me add the second is you're accepting your role as surety. Yeah.
Yes.
So that is the commercial role that you're accepting Remember, thing is the second form of law, canon law. The first form is commercial code. So the first form that you will face when you enter the court is, of course, the UCC. But by unrebutting and not responding to the warrant, not using the reverse, not following the ecclesiastical deed poll, then what in fact you're doing is you are accepting both the role of surety and accepting being a thing. So that is a very difficult position to be in, to kind of dig yourself out when you enter that court. Yes. The other thing that I'm sorry, the other point, just following on from what you're saying, is that in the court, when you face the situation of the judge leaving, well, if they leave without making an offer, then of course you know to stand your ground. If, however, the clerk or the bailiff makes the offer by saying, we'll call a brief recess, and normally, in fact, you'll find even the judge will say to you, we'll have a brief recess. You've been made an offer. If you accept that offer in understanding what recess means, you've accepted the higher jurisdiction. Yeah? That's what I was saying.
Yeah, and I just will add to that we just recently witnessed that. We just recently, within 2 weeks, witnessed this very thing. And
right.
and when the judge came back in for the second time, she went immediately to contempt. And
right. That's right.
And the young man who was standing there, he just handled it beautifully. I was unsure. I mean, he didn't know what he was doing, because afterwards we talked about it. He just did what he thought it to do. So he said, "I'm sorry," and it just totally diffused it. He just said, "Well, I'm sorry. I don't mean to be in contempt." And it just totally diffused the whole situation.
That's an excellent way. And just on sorry, there's a call, as you know, we've got a call on Sunday night where I'm going to be sharing the ecclesiastical deed poll.
Yes.
So a few people on the call may not have had that chance to go through that, and I hope people don't mind, but I didn't kind of schedule to go through the deed poll tonight. But it is a key element within the canons of positive law that the deed poll is specifically designed as a documentary remedy in terms of establishing your standing when you do receive a summons. But the point that Michael Joseph just made about sorry, I hope you don't mind, Michael, and it's great for you to making these comments, because it gives me a chance to cover these points. What physically is happening when someone apologises is that you're watching the operation of mistake and surety. And I actually think it's worth, and Brian, I hope your vocal cords are fired up, because I have a feeling we need to go through this. There is in fact a section, there's a section in positive law that refers specifically to exactly what you're witnessing with that, and it's Article 142 on mistake. And Michael Joseph, do you mind if I get Brian just to read some of these canons out to the call? Hold your questions, because I'd like to cover canon law, and then let's continue as we're going. Is that okay?
Yeah, I'm mooting out. I thank you very much.
No, they're excellent. They're really relevant, and I encourage everybody who have questions, when we call for questions, to please chip in, because the whole point of these calls is to be able to give you relevant answers, encouragement, and insights that are relevant for you, and not simply talking about subject matter that is not relevant. So thank you. And Brian, would you be able to read Canon 1624, which is the first canon of 142? Thank you.
Absolutely. A mistake, also known as a mistake of fact, is an erroneous belief or trust that certain facts are true when committing a reasonable action. A mistake of fact does not exist when an action is considered unreasonable. Canon 1625. The reasonable action in terms of a mistake of fact is any action that would expect to represent the norms of respectful society and behavior, thus excluding such actions as violence, depravity, perfidy, fraud, and other acts considered universally as antisocial and grossly disrespectful. Canon 1626. A mistake of fact is not permitted to be argued when the alleged actions by the person are grossly unreasonable. 1627. In the permitted admission of a mistake of fact, any assured surety for liability from alleged injury ceases to exist. Canon 1628. A person is not considered to consent who commits a mistake. 1629. Any person permitted to admit a mistake of fact must be offered relief to any alleged injury in addition to cessation of any claimed surety for any liabilities associated with the alleged injury. Canon 1630. Any competent authority that refuses to release a person from surety for any liability upon permitted admission of mistake of fact fully consents to assume the liability for themselves. Canon 1631. Any competent authority that refuses to offer relief to a person upon permitted admission of mistake of fact is guilty of fraud and gross injury to the law. Canon 1632. When a person has been deliberately deceived by fraud, then neither mistake nor injury exists. And Canon 1633. Excluding fraud, consent obviates a mistake.
Thank you, Brian. There was a lot to get through. Thank you. So, just referring to what Michael Joseph was saying, and I know that this has been a subject matter that has been discussed several times by several people. This idea of apologising, and what may not have been clear when you've heard of this idea of apology is what form of law and what principle of law is being called when this is done. I know sometimes people have referred to its scriptural nature, but I ask that not to be a distraction. Yes, there is a scriptural element to it, but it is a now well-established commercial reality that when you apologise for a mistake, then effectively, when it's in a reasonable consideration, then you are removing yourself as surety, and then the official adjudicating the matter must then offer some kind of remedy. Now again, judges and magistrates are far from knowledgeable of their own law, much less the law in general and the principles of law. So don't expect every judge and magistrate to do the right thing. In fact, always err on the side that the judge and the magistrate is as ignorant as everybody else in their own court. But I hope this clarifies for those on the call and those that listen to this call, what is the principle and form underpinning why an apology at the appropriate time for the appropriate issue is extremely powerful. Great. Thank you for that, Brian.
Okay, Frank. So if you could kind of go back over each point, because under UCC, you're establishing standing as not being surety, so you are requesting the court for something, and that part wasn't covered. So you're requesting relief or remedy at that point, and then if they leave and come back and you reestablish standing under maritime common law, you've got to reestablish standing. There is a whole different element that you're asking for, care and maintenance, correct?
Yes. Yeah. So, and by the way, that's not common law in the second one, but yes. Yeah, let's start with the first.
Okay. Start with the first. Okay. Yeah.
So the first, how do they get you into the jurisdiction? Well, as I said, when they arrest you and summons you, they already have you on 2 points. That is unrebutted. Silence is consent. Well, they consider it is consent for you to act as surety. So they assume that, particularly when they are arresting you and summoning you on the all caps name of the Cesta KV Trust, and that is exactly the same trust that you have been using, their property, you have been using in having a license, social security, bank account, and all these other benefits that are provided through the Cesta KV Trust. So they got you on that one first. The second is the concept of the thing being the controversy, that by creating the controversy, you have become a thing. That's the legal perversion that they do. But by converting you by controversy into a thing, if they have to come back into court a second time under canon law, then woe be us, because they can very easily and virtually immediately call for contempt if we continue to try and defend ourselves. And normally, and sadly, most people do not know what to do, and if they push the matter, they will go to jail for some time. So let's just go back and answer that, and I'll answer that now, Terry, about the first form of law that we face when we enter their court, the UCC. So I think it's relevant while I do this just to answer once and for all this continuing fraud where they claim that common law still exists. And unfortunately, many people still believe that common law exists. Most countries now, under terrorist legislation, have stated clearly that they can arrest and detain without charge, and that they have suspended habeas corpus, being the right to be heard and to be heard on what charge you are being held within a reasonable time. Now, the origin of those rights I don't think is relevant for this call, but there is a history to them. What is relevant is habeas corpus is the centre of canon law. If a country has suspended habeas corpus, then ipso facto, by fact of law, they have suspended common law. You cannot have common law if habeas corpus and the right to know by what statute you have been charged is not known, and the right to a fair trial and the right to see the information and the evidence by which you're being charged. When those things are being denied, which they are in the UK, in Australia, in America, in Canada, and in many parts of the world, then no one reasonably, rationally, and sensibly could possibly conclude that common law still exists unless they are still romantically inclined to the Hollywood version of patriotism and romanticism and liberty, and the fact that they lie to us every single day by saying that these courts still hold common law. So I really hope that we are not sucked into the continued mask and outrageous fraud and lie that common law in any fashion exists today in the courts of law of Roman-controlled countries. So, sorry for that tub-thumping speech, but I have heard that when I have made the comment before, an absolute fact, that common law is dead, that it has upset a few people, where they've repudiated it. The evidence to prove the truth of my comment is overwhelming, and if one is to suspend the romantic notion in their mind and look at the facts, then the facts are overwhelming to support the reality that common law is dead and buried, except for the fact that judges, lawyers, and politicians continue to vomit the idea that common law exists. So, when you go to court, the first form of law that you face is not common law, it is commercial code. And the commercial code is simply this. When they charge you, they are charging you an injury where the injury is assigned to the corporate person of the Sesta KV, the body corporate, and the Sesta KV is a Sesta KV trust which they have created and they claim is owned. You, in using the property, the body corporate, are implied to accept the surety, and unrebutting the summons or hearing to come to court have already established a precedent just to the court that you've accepted the surety. And unless you state to the contrary when you go to court and start to argue, the issue that you are or are not surety is mute. It's just a question of whether you argue to what degree you are liable. Now, the only way that you can relatively easily, remove yourself in a commercial court from the assumption of surety is to state clearly that you are coming to the court in a different role. You are not coming to the court as the surety to the corporate fiction. You are coming in one of two ways. I have heard of people coming to the court and simply saying, I come to this court as a living man and not as a corporate fiction. Therefore, how can I defend myself when this court will only hear corporate matters? I have heard that defence working, and it's a reasonable defence. In that case, what a competent person, a person knowledgeable clearly by making these comments is showing, is that they realise the courts are dealing with corporations, body corporates of sister KB trusts and estates, and not with flesh. So clearly, if one claims to be flesh, and one clearly says that I am not the surety to corporate fiction, and appeals to the fact that you cannot defend yourself in a court if you are not a corporation or surety for a corporation, then the judge has no choice then but to dismiss it, if they want to dismiss it. Or if they want to challenge it, of course, the judge will almost certainly run out of the court that instant and come back getting ready in the higher court, in maritime law, in canon law, to charge you with contempt. Now, if you don't go down that road of saying I'm the man, the other option is, in your knowledge of the fact that a divine trust and a true trust has been created already and is clearly stated in the canons of positive law, then you can say, Your Honour, I stand here as a trustee of an express trust, not as a surety to a sister KV. Now, if that's the case, then the judge has a real problem, because now what you're saying is not simply that you are no longer the surety of a corporate fiction, but that they can't even claim that you are consenting in any fashion to being surety, because you're not coming to them in commerce and trade as the beneficiary using the corporate name of a sister KV. You're coming to them as a trustee of a wholly different trust. Now, I would strongly advise that these are not words that you simply cough up in a court matter without having read positive law 3, 4, 5 times and knowing exactly what we mean by trust, divine trust, true trust, estate, sister KV. But if you have read that, then you'll understand what I'm saying. It makes perfect sense. So, Terry, does that answer the first form of law, being the UCC?
Yes, that answers the first situation, in a court situation. And so continue then with the next, when they come back in under the canon maritime.
Okay. Well, under the canons of 1983, they no longer use terms like sailor of a ship. They use the concept of a traveller. So under canon law of 1983, there's essentially only two things that you can be: a thing or a person. And what you don't ever want to be is a thing. So in order to establish your position under canon law, very simply, is to establish that I stand before you as a living man. The blood flows, the flesh lives. And, Your Honour, I ask for cure and maintenance. Now, why would you call cure and maintenance under canon law? Because in the most ancient form of canon law and the principles of canon law, maritime law, under what's called the rule of Oleron, from which the earliest canon law had been derived, a sailor of a ship they were obliged, when a sailor of a ship was found, to provide cure and maintenance, even if it was a sailor of an enemy. Now, this holds true even to today. That is that the judge is obliged, once you've established that you're a man or a woman, I should say, man or woman, and that you're a living man or woman, and the flesh lives, the blood flows, then surely you are a natural person, and a natural person is identified in canon law of 1983, clearly identified. You cannot be called a thing once you've established that statement of fact. Okay? Does that make clear, Terry? Or not?
Yes, Frank. That's very clear. And is salvage also in where they would consider you a thing? Salvage, also a salvage? Okay.
Correct. So the way it works is, if you do not state that you're living, then they can use the fact that there's a Sesta KV against you. They've got the standing of sending the note and you're not responding. The controversy has turned you into a thing. Therefore, you're a thing. Therefore, they can apply salvage. Therefore, they can order that you get taken to a warehouse. Okay? It's that simple. The minute you establish that you are living in a body, flesh, blood, competent mind, however you want to say it, but in that combination, then clearly you cannot be classed as a thing. You must be classed as a natural person. You have to be. Now, as a natural person, you can then request for some form of cure and maintenance. And what you're then asking for is a negotiation. Yeah? Now, I am a living man. I stand here before you, and I apologise, Your Honour, for the mistake of fact. Now, what have I just done then? I've established that I'm a living man. I've established a competence because I've apologised, the mistake of fact. So clearly I've established competency in the same go. And I have offered to the court a form of remedy, which is to remove the assumed surety between me and whatever the injury is. Now the judge has to respond. Now I'm referring to the judge has left and returned. If a judge has left and returned, then clearly they are trying to use canon law. Clearly. I mean, that no one should, they're not going to the toilet. I mean, that is, they've come back in, they're going to try and use the second form of law against you. So once I've established that I'm living, I'll apologise for the mistake of fact, then the judge really has to think very carefully. They can't claim contempt. They can't, because I have to be a thing to be in contempt. They can't use that. They can't say, I'm not going to accept your apology. The only way they could say that is that I'm trying to apologise for something like murder. Well, you can't apologise for murder because it's not reasonable. It's an unreasonable action. But for most of the stuff that they want to grill us on, a heartfelt apology of mistake of fact is more than enough. So that is the remedy specifically that we should think about in the second form of the court. So how does that sit with you, Terry?
That's very good explanation. Now, if it should happen, which would be a risk on the judge's part, if it should happen that they go out a second time and come back, can you go through that scenario?
Yeah. Well, if they leave for a second time, and I doubt that any of you will ever see this, if you do see it, it would probably be in the setting of a tribunal, that is in a court of appeal, which is the true court. A true court is always a tribunal, so don't ever think that a single judge in a court is a true court. A single judge in a court is an administration court. The judge is really sitting there as an administrator. They may call it a court, but it's only when there are three judges is it a true court in the ancient definition of what a court is. But if you do encounter this, and as I say, I think it would be very rare with a single judge, then that judge feels pretty confident that they can get you on the third and final form of law, which is Talmudic law. Now, Talmudic law is the implementation over the last 30 years of a form of law that the Khazarian parasites that have had many names, they've called themselves the Venetians, they've hidden themselves as the Ashkenazi, they created the 16th century fictional name where they melded the Yahud and the Israelites and the Menashe and called them all the Jews. These people are not Jewish. These people are not Menashe. these people are whatever they want to be. They actually, the one common denominator is that they hide in a host, they believe in nothing, and they are certifiably insane, which is a scary thing, to think that people who claim to run the planet as bankers, as lawyers, as members of the Anti-Defamation League are certifiably insane. That's what you're dealing with, people who are certifiably insane. But if you do get a judge that wants to challenge, then what Talmudic law is effectively the implementation of the Noahide laws, where unless you establish yourself as being, in their mind, and remember they're coming from extreme ignorance, and this was implemented in extreme ignorance, unless you are Jewish, unless you are standing Jewish, then you are, in their mind, a goy, a goyim, and a goy and a goyim in Hebrew is cattle or a dead corpse, and then they have every right, if you are not a property holder, to send you off and have your head chopped off. At the very least, to send you off to jail for 20 years, even if it was a parking fine. And I mean that, even if it was a parking fine. Under the third form of law, they can send you off for 20 years and it's perfectly legal. Of course, the problem they have is that the whole concept of this Talmudic law is based on ignorance. The Talmud, being written by the Menashe, that's Menes Hay, was written not 300 BCE, 400 BCE in Babylon. It was written in Syria. It was written by the Menashe, and it was written in the 4th century CE. And it was written as an antithesis to imperial Christianity. Furthermore, the Noahide laws weren't written till the 15th century. Furthermore, the term Jew, written in the 16th century, when these Khazarian parasites took control and wanted a catch-all phrase in which to hide themselves, when the name appeared, extraordinarily, the word actually means goy. The word Jew means goy, goyim. It doesn't mean Israelite. You can't get Israelite from Jew. You can't even get Yahud from Jew. Some divine force was at work in the 16th century when these wicked parasites that now control a lot of the planet today came up with this word to hide amongst good people, honest people, people who have no idea, would find this extraordinary. And in actual fact, under the law of the Talmud, it is the Israelites that hold the law. It is the Israelites that are the just, and it is the goy that are the ones to be gathered up and scattered as dust. So when you stand in a court in the third form and say, Your Honour, I am an Israelite. I am an heir to the Talmud, as it is written, not a goy. I do not call myself a Jew, because to call myself a Jew by the 16th century fictional word, as opposed to a Yahud or an Israelite, I am saying I am a goy, a goyim. Now, if their name was Spiegelman or something like that, because I can assure you that in most cases it'd be a very brave judge to think that they can run the third form, they would turn white with horror, absolute white with horror. Because once you establish your standing as one of the chosen of the covenant, as an Israelite, and show even the smallest understanding of this, they have absolutely no power over you. And in factual fact, the judge risks himself being classed in that form of law as the goy. Now, in order to discuss this more, really, the ecclesiastical law, which is still being finalised, needs to be finished. But I think enough is said. If you go and read the 6 pronouncements of Eucadia on eucadia.com, then I think you'll find more than enough background to understand exactly what I'm saying and the truth of what I'm saying, that all on this call are Israelites, and that it's only when a man or a woman stands arrogantly up, calling themselves a Jew or behaving and acting for these parasites, that they are the Goy and the Goyim. And under the covenant, they are the ones who are subject to the penalty, not the Israelites. So does that make sense, Terry?
Yes, that was explained very, very well. Thank you for that explanation. I think that covers it very, very good. And we did have a question from guest 16 a little while back. Now that you've covered the court scenario, what about avoiding the court? Right?
Well, that is the preferable. And I don't recommend anyone thinking that action in the courts is going to get easier, because this is what is going to happen before we answer that question. This is exactly what's going to happen. There will come a time very soon where they'll simply stop pretending that they are representing the law whatsoever. And you will then face the type of system that was used to administer the world and civilizations for thousands of years, and that is force, fear, and intimidation. So don't think that by doing this that ultimately they're beaten. Far from it. All this is doing is accelerating the dropping of the curtain. And the dropping of the curtain is that these people in any way represent the law, these people in any way care for the law, respect the law. They're not. They're parasites, they're tyrants, they're bullies, they're sociopaths. So all that's going to happen is that over time, that process is going to accelerate. So it is going to come where you'll find that people who are going to court, no matter what they do, are going to find that the judges are simply ignoring every form of law. Talmudic law, commercial code, canon law, and it's simply just going back to Star Chamber stuff in Russia or Nazi Germany, where it didn't matter. They just simply send you off to a concentration camp. So just keep that in mind. As far as avoiding the court, which is the preferable thing to do, we go back to the original thing of how do they get you to court? Well, they can arrest you. They can arrest you and not charge you. And this has happened, as you know, a number know that this is something that is usually the most common way of arriving to their court. That is, they'll arrest you on some traffic stop, or they'll come to your home, or they'll come to your work. They'll simply haul you off. They'll choose to charge you when they choose to charge you, and then the next time you see daylight, if at all, is in the court. But if that's not the scenario, and you're given the opportunity at least to be given some paper, then it'll be in the form of a summons, a warrant, or some hearing date which will come to you. And when that comes to you, what you have is you have one window, and one window only, to respond. And it is a feature built into the very nature of what a document is. And a document is formed from two things. The front of a document is called the obverse, and the back of a document is called the reverse. Now, this is something that has existed in law from the beginning of law and the beginning of documents in law. The obverse, and in fact the entire document, can never ever be materially altered. If you alter a document sent to you, even if it's a crappy photocopy, and let's face it, they're not big on the quality of their documents. They might send you something nice and snazzy sometimes, but they're more than happy to send you barely legible things in the mail.
Frank, did we lose you?
Did Frank drop off? Did Frank drop off the call?
Looks like he fell off for a moment. You're seeing some of the chat questions. Did you want to answer any of those for us?
Sure. I just want to also say that in regards to the obverse and reverse, that the reverse of a document is the spiritual window. In other words, it's a medium of putting something on the reverse of a document in which to send a spiritual message back. Someone was saying about the Sanhedrin.org. I have never been to the site, so I can't give any opinion on it. The other one is, should I carry a deed poll on my person? First off, the deed poll serves several functions, and one of those major functions in regards to the SESTA-KV in the standing is of competence. And in that, you'll see that there's a section about a mistake of actually using their SESTA-KV. So basically, it's something that can be done on a document that's sent to you, and you put it on the reverse. Now, when Frank comes on, he will speak in detail about this.
Yes, he will be able to explain the rule or law of reverse. So,
hello, back again.
Yeah.
There he is. Okay, Frank.
Yes, telecommunications.
No problem. Yeah, we were talking about obverse and reverse.
Yes. So there's two forms of a document. There's the obverse and reverse. And if anyone wants to understand this more, we won't read out the canons, but in fact, no, we will, because the canons are written to make it easier. Let me call this up. Brian, would you be able to? Article 22 is document.
Sure.
We won't go through. Yeah, we won't go through the whole lot. What we'll just do is get down to this.
So go to 7. Yeah.
Yeah,
Okay.
786. Yeah, 786.
All right. Sure. I'll read 786. All documents, whether valid or invalid, have at least one obverse and one reverse, with the primary and most ancient purpose of the front or obverse as the window transmitting the purpose and message of the document, whilst the reverse provides the window transmitting any formal reply or rebuttal.
Does that make sense to everybody? You understand that is the ancient form of document. The front tells you something. We want you to go to court. The back is your rebuttal. Don't worry if the back's got writing all over it. That's immaterial. They do that. Don't worry. The back, the reverse, is your window to respond. Keep going. Thank you.
Sure. An ordinary document is a valid document issued and sealed by an ordinary official person, registered in the Great Register and Public Record of One Heaven, and existing firstly as an ordinary spiritual and ecclesiastical instrument, and secondly as an ordinary temporal ecclesiastical instrument possessing full living personality. It is the third highest and authoritative document of all.
Well, which one was that one? What
that was 783.
Excellent. Yeah.
Yeah. Why don't I just do 779 just to explain what a document is?
Yeah, go for it.
Sure. A document is a notional form of spiritual or temporal written instrument of one or more pages, with each having a front face or obverse and a back face or reverse. There's only 5 valid forms of documents: supreme, superior, ordinary, general, and inferior.
So we'll just stop there for a sec.
Yeah.
So, thank you. So what we're saying here with these canons is that when you receive a summons, even though they don't tell you, and they never will tell you, you have the right to use the reverse as a window to respond to their claim. Now there are a range of tricks that they've used over the decades and even centuries to stop people finding remedy. And in the present climate, those include things like not paying stamp duty, the document not being recognised. One of the classic ones at the moment is the dead can't write. So you can't send them a document when you're dead, because then they can say, we've just received, have you heard this before, a dead letter? They've received a dead letter. So when you use the reverse of one of their documents, then you're in fact proving that you cannot be dead, because you're sending back a document that is already verified. They've sent it. They can't deny a document they've sent you. They can't. It goes against all their principles of law. What you can't do, as I was saying before I lost connection, is do not listen to anyone ever that tells you to alter a document in any way, to sign it, scratch it, put words on it. If you do that, you are giving them documentary evidence of an extreme dishonour. You have lost the case before you ever arrive. Do not ever do that. And anyone that has ever promoted that has either been a complete idiot or a willing disinformation agent for the Bar Association. They can only be one of the two. Because you cannot alter that document in any way without accepting the liability. But this is what you can do. You can get a stick of crazy glue and you can glue something on the reverse. And that's how you overcome the issue of there being writing on the back of a document. And it's how you overcome the issue of changing that document then in a material way. Now, you use crazy glue because you don't want anyone in their system to be able to separate the two and play that game. If they want to do that, they'll destroy their own document and they'll destroy yours, and they've committed a serious, serious breach, serious fraud. Now, the document we'd like you to send back, if you're looking for a remedy, is what we're saying, which is the ecclesiastical deed poll. Now, Brian and Terry, do you think it is worth, given there'll be a number of people on the call that have never heard us talk about the deed poll, just to quickly mention where they can view that?
Yeah, and also I believe because it's on TalkShoe, it'd be just a good intro as well.
Okay. Well, because I am still very keen, and we've gone over the hour now, and I was still very keen to be able to answer questions, and I still want to cover this area of natural law, divine law, and what the whole goal of this is. What we're referring to is Article 133 of the Positive Law on One Heaven, and that article goes through and describes the definition of what an ecclesiastical deed poll is. It gives the instruction, in fact it gives you the precise words to be put on it, and explains exactly how to use it. So maybe this, can I just do a quick recap of what I wanted to cover? So it might be a second, just to cover what I wanted to talk about in terms of natural law, divine law, and the whole gist of what this is. And then we can get into Q&A and we can talk a bit more about ecclesiastical law. Is that okay?
Sounds good.
Yep, that
Okay.
sounds good, Frank.
All right. Because we're talking about positive law, I know a number of you may not have had the chance to read or view the canons of natural law, and may not even have had a chance to look at the canons of divine law. But I do urge you and ask you, when you have a chance, even though it may come across as gobbledygook, to actually go in and have a look, if you can, but start from the beginning of the canons of natural law. Because in that there is some deeply, deeply important and profound understandings and wisdom, where there is a serious attempt to give light and understanding to the laws that we may call physics and chemistry and science, cosmology, in the context of life being a dream and that the divine creator is in fact the dreamer of that dream. And I refer to that because it is easy by focusing on this kind of area, being positive law, the laws of men and women, the laws that we make, that we lose sight that those areas of canon law have already been written and exist there. So if we are talking about, for example, the question of relevance or the question of significance to ourselves and to our present situation, we're really only covering a fraction of the law if we don't take the time to view what is already presented to you being the divine law and the natural law, and literally is the divine law and the natural law, all the key natural law that has been researched over 25 years to try and bring that into a summary document. Now, why? There's a fourth coming, which is ecclesiastical law, which will be up very soon in the next couple of weeks. But the question then is why? And what, how? Well, when a man does not assert his rights, he has none. And I've said this before, but it's relevant. When Martin Luther saw the Express Trust Canon being Linum Sanctum issued in 1302, he understood the significance that the Roman cult needed to have some formal objection. Now, his approach was to dismantle the assumptions that they were making. Now, the 490-odd years since he did that, of course, the Roman cult continues to learn, to grow, to find new ways to stay in power, as they're doing next week, when all the cardinals, including a number of leaders of Christian groups, will all find themselves in Rome at the same time under apparently different motives. But I can assure you that the extraordinary events of next week have more to do with Rome consolidating and growing and continuing to find ways to stay in power than any kind of mea culpa and change of heart. So the canon law here is to show, without a shadow of a doubt, a superior form of law, and to recognise a principle of law that has existed in every civilization from the beginning. It is a definition of law. And that is that unless you object, then you consent. Now, it's perfectly fine to sit out and say all law is fictional, what the Roman cult does is wrong, it doesn't really affect me, it's all rubbish anyway. I don't dispute any of those things in terms of their approach to law and creating fiction. But you cannot avoid the fact that if you do not enter the arena, then you give the match to the Roman cult. And this has been the problem. Martin Luther is the only man I know of in the last 492 years that has stood on the amphitheatre clearly, concisely, and given some form of argument to say what you're doing is wrong. And he pioneered an entire protest movement that, as we speak next week, is coming to an end. It's over. It's lost. There is no Church of England now. It's just a branch of the Catholic Church. So in this time now, I urge anyone that's reading this and acknowledging this and seeing this, that if you do not stand, then you consent. If you do not object, then you consent. And if you consent, you are nothing more than a slave. And that is the problem that we face. Too many are happy to be slaves, willing to be slaves, wanting to be slaves. Well, that's why we're here. We're here to challenge and say no. That's the reason for the canon law. So I come back to you, Terry, Brian, and everyone on the call, and ask for questions as we discuss now ecclesiastical and questions that you guys may have and want to ask based on what you've read or what you'd like to hear. So over to anyone that's got questions.
Okay. Anyone that has muted or that is muted, I think I unmuted everyone except for Montana. *6 will unmute you if you would like to ask a question. You'll do a *8, that way I can kind of take you in order and not conflict with anyone. for those of you that are on the phone. Those of you that are in the chat and not on VOI key, you can type in your questions in the chat box. Dawn, out in Montana, did you have any questions possibly?
Yes, I have a question.
Okay.
Would you please clarify what you mean by property holder?
Yes. Thank you for your question. There's two things there. There's the holding of something and the significance of what that does, and then there's the question of what property is. So let's start with what property is, and then we can talk about what holding something does, if that's okay. So when we say property, and I think this is something, I'll read this out just because I'll call it up. One of the things that the whole system we're dealing with is based on property, and I'm sure you realise this, that property is a crucial form of law and part of law that runs the entire planet. But what they try and get us to do is think of property being the physical home, the physical car, the stereo, the computer. That's what they like us to believe. In actual fact, property is nothing more than the right of use. So I'm going to read out Canon 1114, that's Canon 1114, under Article 80 of Positive Law. And I won't go through them all because I want to answer your question as quickly and as clearly as I can, and ask you, if you can, to go and have a look at these sections after my answer has maybe further clarity. But property is any fictional right of use expressed into a trust relationship with other forms whereby there exists a claim form of ownership, form of trustees administering the form as property, and form of beneficiaries. Hence, property is the rights of an owner to use the form, never ownership of the object or the concept itself. Now, the way to think about this is this. If you look at physics, there is no law in physics, chemistry, science that says I can own you, or you can own me, or I could own, 100 animals, or that I can own anything. There is no law of ownership in physics. Ownership in that sense is a fictional idea, an idea that we have worked out ourselves. So in reality, there is no one on this planet that can claim a superior right of ownership of our own. There's only one thing ultimately that really can claim all ownership, and it's the idea, the concept of the divine creator. So if the divine creator is the only thing ultimately that can own anything, then what the Roman cult worked out is that if they claim to be the sole representative of the divine, which is exactly what they did in 1302 in Unum Sanctum, then they can claim to hold all property as trustees. They can control the dispensation of property rights. Now, before I get to the word holder, just keep in mind that when we talk about property, we talk about rights of use, and because of what I've just explained, it is a top-down principle. Claiming is the opposite. Claiming is a bottom-up principle. So when we say claim of right, what we're saying is I, from the bottom up, are claiming a right from the top down. So those canons there on property hopefully answer what we mean by property. Now, in terms of holder, a property holder, holding is a very important concept in their system, and holder is listed under, where are we? I probably can't see it for not being able to see it. Where is it? Holder.
Want me to read that out, Frank?
Under holder? No, just
yeah.
Can you tell me which article it is?
It's Article 78.
You see, it just shows you I can't even see what, there it is, 78, yeah. So just, all I'd say with holder is that when you look at that, it explains to you that effectively when you are holding an instrument, then you are consenting to be surety. So let's say that, let's talk about property holder being a license, for example. Okay? So let's say I'm holding a license. Well, that license is issued by the Department of Transport. It's issued in all caps, so it's in fact a benefit, a property right that is given to the Cesta KV, not to us, because it's in all caps, and we're given the license. So effectively what's happening is that we are becoming the surety for that Cesta KV in the property that is given to that, the right that is given, which is to drive a motor vehicle, given that all the motor vehicles ultimately are owned under legal title by the particular state that we live in. So if we produce that and we show that we're holding that, then we're consenting to the surety and the obligations that go with that property. So I don't want to read out all the detail in Article 78, if you don't mind, because it is there, but hopefully that will give you some background. And hopefully I've answered your question, or at least given you some direction as to answering your questions about property holder. Did I?
Yeah, yes, thank you very much.
Okay, great.
Okay, Frank, thank you. We've got a question here on the chat here that a couple of questions regarding the deed poll. First
Yes.
of all, on the deed poll, signing in blood, Cesta K is formed with blood. Does this present a problem in terms of grant?
Well, it does present a problem for the system, a big problem, but that's an intentional problem, and it comes from, and the system will throw up all kinds of protests, and there's a reason for that. The most powerful, so when you think of a document is several things, and again, the definitions of document are listed in the positive law, but think of it this way. A document is firstly a medium. It's something. It could be cow skin, it could be calf skin, it could be written on cardboard, it could be, any kind of thing. And then there are words associated with it, and then there is a format for those words, which is the form. It's why when we send things into the system, they ask and request for it to be called something. So we're calling an ecclesiastical deed poll. Other people might in the past have thought that calling something a declaration was a good idea, or a statement of claim was a good idea. So these are all formulas to, if you like, a bit like a spell, in fact exactly like a spell for the Roman cult, in defining the nature of the words. But let's start with the form first. When you write on pieces of paper and sign, those pieces of paper and that paper is paper. There is no life to that paper. Your words might be passionate, but it's dead. So the medium is dead. But remember, the Roman cult and the Khazarian parasites have been doing sorcery and magic tricks for a long time. And they worked out something very important early on about magic and spells. And that is the medium in which the document is created, the medium on which the words are written, plays an integral part in determining how powerful the message. Now, there is nothing more powerful than a medium that is considered living. Now, this is from their mind, not mine. This is their world, not ours. Do I think putting blood on something is a good idea? I think it's crazy, personally. But in their system, in their world, in the world of mad, psychopathic people that are running this planet, it doesn't matter what I think. What matters is that I can get through layers of madness. And one of those layers of these sorcerers is the belief that when a medium has life, then it is superior in form to anything else, regardless of who sends it, regardless of what is contained in those words. So it is by no mistake, and I prepare you for the truth of this and the shocking truth of this, that when the Roman cult wrote their most powerful documents, they wrote them on the skin of murdered children. And they call that vellum and parchment. And in actual fact, in the Grimoire Verum, there is the preparation of vellum, and they call the child a kid. And it explains precisely and exactly how to prepare parchment for use, exactly like papal bulls, spells. So the principle is that the spirit of the child carries with the parchment and gives the parchment life. Now, what does this tell us? It means that they understand in their system of sorcery, where a judge is wearing the black robes of a gala tendon of the dead, that they full well know what blood does when infused on paper, particularly with intent, especially with intent. As it states in the first statement of the ecclesiastical deed poll, hereby give life and personality. We're giving life and personality to the document. The document is living, has its own life. None of their documents have life. Why? Because we've sealed it in blood. And when blood is put to paper, we don't have to go out and do their sorcery tricks of murdering children. By us spilling our own blood with intent to stand for the law, we give life and personality, and not one of their minions have any right to abuse an ecclesiastical deed poll, because if they do, by their own rules, it is the worst thing they can possibly do. So, personally, putting blood, I would rather not. But when we're dealing with a system, and the fact that the system just continues to crunch people and crush them unending, and you're asking for some divine help to stop that, then absolutely, there is no other way.
Great.
Did that answer the question? Yeah?
Yes, thank you, Frank. That was very good. Now there's a couple of folks that asked you to outline what not to use the deed poll for.
Well, that's a fair question. I prefer to leave that to the judgment of each individual man and woman, trusting your judgment and the fact that you will treat this with respect. What I don't want you to do is to feel that when you send it, that you will automatically get the kind of response that you should get, and that the kind of respect that you should receive. Remember, we are dealing with ignorant people who are asleep. I mean, the most ignorant people of the law are, by definition, those people that work in the court. Why? Because that's exactly how they've been trained, to be ignorant. So don't expect that when you send back a deed poll on the back of one document that is going to solve issues there and then. It may not. I've heard of, in fact, already someone sending a deed poll and that document being untouched, by the way, no mark on it, but the original and the deed poll glued together, sent back in an envelope with the envelope saying rejected as a vain attempt to try and get it off their hands. The answer was send it back, which they did. So there is going to be those kind of games that people play. So the short answer is, if you're under attack from an alphabet debt agency or a court or a bank or anyone in the system, then the ecclesiastical deed poll is there to assist you, however many times it is required, until they understand that the deed poll doesn't create a trust relationship. It merely gives witness to the fact that the trust already exists. So however many times you need to send it, send it. And keep sending until the message is clear. That's, I think, the best advice I can give anyone.
Yes, very, very good, Frank. Thank you. Question from on the chat. How about hearings in chambers? can the judge still change the form? You know, when we were talking about the court issues.
Well, that's their chapel when you speak to a judge. And I know that it might sound exciting to go and talk to a judge in chambers, and there may be judges that want to. And I feel in future there will be more and more judges in the coming weeks and months that will want to request a hearing in chambers. But a hearing in chambers is a double-edged sword. Remember, that judge has spent a long, long time and is by definition someone that usually is considered quite intelligent. And unless you are on top of exactly what you're doing, you may expose yourself in such a fashion to show that you are not as competent as you may have claimed, that you do not fully understand what you're dealing with, and if a judge gets whiff of those things, may then use that knowledge when you return. Remember, a judge is not calling you into chambers because he likes you, because he wants to help you. He's calling you into chambers because the judge at that point is struggling to find a way to beat you. So don't be sucked into the, I'm your friend and I'm here to help you, like I'm an attorney, I'm here to represent you. No. So the short answer is, if you're requested, you may choose to go, but don't see it as a far-side chat or a way to chin-wag or prove. Your hubris or any kind of cockiness could well be the cause of failure. But I wouldn't shirk from it. I wouldn't want to run away from it, but treat it for what it is. It is nowhere near a fact that you're winning. It is merely a judge trying to explore how to beat you.
Yeah. Thank you, Frank. All right. I don't know if Michael Joseph can come back on a line. He's put in a couple of questions here. If I give up my original, I'm sure that means document like summons or warrant. Hopefully, Michael, just let me know if we're off base here. Can that not be interpreted as a grant?
Okay. Well, it's important, I think, okay, in originals, copies is relevant because they use words like extract, certified copy, original to us all the time. It's actually a ruse. A bank can monetize a piece of tissue paper if they wanted to, and it's perfectly lawful. In fact, they monetize things that have been photocopied, faxed and smeared 100 times over, have done all the time. So whether something's an original or a copy is immaterial in their system, totally immaterial. What is material is whether the document is the form of execution or is a copy of execution. So if I'm talking about a deed, the form that conveys property is considered a deed. Now, it may not have deed on it, but most deeds are supposed to have somewhere on it the word deed. That's just a general rule in their system. A deed is a deed. It is the form to convey property. So if I'm going to grant a right or convey a right, then it needs to be in the form of a deed. And unless the deed has some originating form to it, then no. In the case of the ecclesiastical deed poll, we are sending originals, but in no way are we conveying, can it be construed as conveying any right at all. Now, deeds are very clear, and the rules of deeds are very clear. Unless you state clearly, grant, give, consent, then you are not consenting, you are not granting, you are not gifting. So unless those words are used in the context of a conveyance, then you're not granting, giving or conveying anything. So if you read the deed poll very carefully, it in fact is not gifting or conveying any property rights of the trust. It is using words to effectively convey rights. that relate to where we stand in and agreement to where we stand in their system. So they're rights that, in fact, the recipient is agreeing to, not us. And that's what makes the deed poll very powerful. Once they receive it, unless they rebut it, and they can't because of its form, then we have a binding deed and contract where they agree to the fact that the SESTAC-OV can't stand. They agree to the fact to give an accounting. They agree to the fact that we don't accept coercive or punitive benefits. They agree to the fact that we have a superior trust position. They agree to the fact that we're a trustee. That is what we're doing.
Okay, very good. Also, for Michael Joseph, why would I not set my own boundaries and borders around my own issue? Question mark, and then private question mark.
Do not, I hope, for anyone, and this is going to be one of the most difficult things for people. I know, look, there are people who've been doing things for 20 years and 30 years and longer, and when I approach this, I really do approach it with enormous respect for each and every person who's been battling. But if you materially alter even a fraction of the deed poll, other than replacing your name, then it is no longer a deed poll, it is no longer part of divine law, and you are dealing as a single individual without any of the force, support, power, or influence of any of this. You are going back to one man or woman battling the entire system. Do not change a single thing. Now, if something inside you is almost overwhelmingly compelling you to say, but I do not do anything without me giving it my own twist, maybe that voice that says, I don't do anything but my own twist, needs to be very carefully looked at, because here is a very specific and clear instruction. This cannot be altered without fundamentally changing its effect. There are many things that you can do of your own. For example, I've said to a number of calls, by the time you've read the canon law 3 or 4 times, trying to remember the words will become immaterial, because what you will feel is a vibration. That vibration is the fact that the word has become you, and you have become the word. In other words, you won't need to worry about what it says word for word on documents or property or SESTAC-OV. You'll know it, and how you say it in court will be your own. Now, that's a classic example of using your wisdom in oration, in speaking, to strength. But when it comes to written form, it is a very dangerous, and I have to say, because there's no other word to say, foolish thing to consider changing material form when it is made patently clear that by doing so you are creating an entirely different and inferior system. So speaking, absolutely. Speaking, there's nothing stronger than a man or woman that knows the law to the point that they can use in their own words and express in their own way their competence, because that is the strongest proof of competence you could ever see in a court. But when we're talking about form, do not deviate 1 inch, please.
Okay, Frank, this might be a good spot to put in an explanation and talk about the blue paper that is also included with the ecclesiastical deed poll, because this is possibly, with some of the ways, and these are good questions, because these are things that we're even encountering currently about establishing boundaries on the documents. And so this would be a good spot. It seems that it would be a good spot. I don't know what you think about explaining the blue paper.
Sure. Like, why is it on blue? Well, it does explain in the canons why, but I'll just give the history of it quickly, the quick history. At the turn of the century, I think it was about 1908, there used to be a court that the Roman cult established, and they squashed it at the Council of Trent in was 1545, around that period. It was called the Sacred Rota, or the Rota Romana. And the purpose of the rota, and rota meaning wheel, torture wheel, was to hear matters, jurisdictional matters, a bit like the Supreme Court. So the highest court is the Curia, the highest judge is the Pope. So one down from that was the rota, and the rota would hear disputes in territory and vassals of the Roman cult, and it was closed down. But in 1908, they reconstituted it again. But instead of putting physical living beings on this rota, they did something really tricky. They stated that the court was in session with 12, and they call them 12 apostolic proto-notaries. So that's 12 apostolic proto-notaries. Now, the word apostolic and the number 12 hopefully should be obvious to most people, that we're talking about something equating the apostles. And that's precisely what they did. Without being obvious about it, what the Rota claimed from 1908 is that the 12 apostles are sitting in judgment on behalf of the Roman cult in a spiritual court called the Sacred Rota, the Rota Romana, every second of every day, because the court is in session all the time, and of course they're spirits, so they don't need to go to the toilet or sleep. And that court then grants certain powers to courts around the world. So when those courts want to use those powers, those superior powers, the instruments are issued under certain colour, yellow and blue. Blue being the most traditional, Robinette blue being the most traditional colour for the claiming power of the Curia and the Rota. So when you have a proto-notary judge in a district courthouse, he or she is claiming their power from the Rota. So let's look at the logic, and this is where it comes in. And this comes to the heart of anyone that says, oh, I still don't believe that they've closed common law. That's not true. I believe in the romantic notion. Well, let's look at it. If I want to arrest you, then under common law, I'm really entering in negotiation. If I'm really talking about common law, right? I'm saying I've come to arrest you for this reason, and then, yes, it's all very civil and off you go. But if I'm coming to your home with a SWAT team and I'm bashing down the door and I'm shooting your dog and I'm scaring the children, well, I'm not coming to negotiate. I'm coming to enforce. I'm coming with jackboots. Now, if I want to justify that with law, I need something with a little bit more oomph than common law. I need something that says I have been granted a God-given right to do that. Well, that's exactly what the Rota did. And the canon law in 1917 was the first time they used it. And it's been so successful that they've souped it up in the 1983 version. So what happens is the proto-notaries issue warrants of arrest using the full ecclesiastical powers of the Rota. Well, they're using spiritual and supernatural powers against us to arrest us. They're saying that the apostles, Jesus, God, has given us a right to arrest you. That's how they arrest you. That's how they imprison you. And that's why we're using ecclesiastical blue. How's that? Okay?
Yes, that was very good. Thank you, Frank. Another question. Does the use of the driver's license give you liability or claiming ownership of it?
Does the use of the driver's license give you liability? Well, in their system, what they do when they give us equitable title is they also give us the obligations. So when you hold a driver's license, absolutely, you're also accepting the obligations that go with it. So yes, you are accepting liability. Ownership. Well, you only can never get equitable title under their system. They don't give legal title. And, of course, legal title is granted to the trustees, and you're not the trustee. So you have the right of use in equity, which is a lease, a tenant, but nothing more. So I kind of need a bit more information before I can sort of qualify that further. I don't know if I've answered the question exactly what was intended.
Yeah, I'm not sure either. Maybe Brian knows a little bit more about what.
Well, one of the parts that the driver's license is the severity of the obligations as what they actually see as the benefit. So, for an example, enforcement of, like Frank actually said about the jackboots, is actually seen from their standpoint as a benefit. So the driver's license is a nom de guerre. That's why usually the last name is first.
Okay.
Very good.
Thank you, Brian. All right. Another question. Aren't we the only ones that can condemn ourselves by giving first-hand testimony?
Are we the only ones that condemn ourselves by giving testimony? No, because in their system, silence. We condemn ourselves in silence. We condemn ourselves in when I say running away, I mean not that I'm not saying anyone's a coward, but by not addressing it in their system, yes, we condemn ourselves. We condemn ourselves by not objecting. That's probably their biggest argument. If you look at the history, and this is probably one of the most astounding things that people don't realise, when people create conspiracy sites and say, look at this, like look at 9/11, there are two things that the parasites and the ruling elite have done dutifully virtually every time. One, they have given multiple public notices, multiple times before they commit an act of extreme evil. And most often, Hollywood will commission a film, several films, so that it is unmistakable. Books will be commissioned, so it is unmistakable that this is what is going to happen in the future. They scope it and say this is what's going to happen. And then when it happens, of course, they make a sacrifice. So they give notice to us before they commit their evil. And if there is no objection in the public notice aspect of what we're doing, then we have condemned ourselves, absolutely. But I have to say that one of the biggest changes in the last 2 years, and it's almost gone unnoticed because of the global financial crisis, is that we were, I feel, almost without a shadow of a doubt, facing a major negative action that was going to take place, certainly in a number of key places. That seems to have abated to the point that there almost is coming out an unmistakable series of signs that there is now extraordinary infighting amongst the ruling elite. So that's an extraordinary turnaround of events, however that has unfolded for whatever multitude of reasons. But condemning, in their eyes, is lack of objection more than anything else.
Okay, yes, that makes sense. Okay, next question. Does the force come from the established definitions at oneheaven.org? We didn't really cover where those canons have come from or maxims, but this question is, does the force come from the established definitions at oneheaven.org?
Well, that's not a bad question. The answer is the force comes from when you believe the words and you live the words and become the words. It doesn't come from the fact that I wrote them. That is a significant difference in this. You need an author, sure. You need a witness, sure. But what are the first 5 words of the ecclesiastical deed poll? Because this is the turning point. When you send an ecclesiastical deed poll, the first words you're saying, after per curiam divina, is, we, the divine, immortal spirit. That's what you're saying, not Frank OCollins, Brian or Terry or anyone. So when you're doing that, you're giving notice to something that was, well, said to us 2,000 years ago. I mean, if you believe the words written 2,000 years ago by the prophet, the character variously called Yeshua, Messiah, Jesus, whatever label you want to say, then one of those is that the mystical concept, I'm in you, you're in me. So when you say we, the divine immortal spirit, you're stating quite categorically that no one stands between you and the divine. No one. Not Frank, not a pope, not a bishop, not a guru, no one. You're taking ownership. You're taking claim. That is the force. There is nothing more powerful in the universe than that. Now, okay, I have to take some credit for this, and it is a blessing and a burden. You know, it's a joy and a trial sometimes to do this. But that is the central message. And these canons mean absolutely nothing unless in your hands, after reading them and studying them, the words become vibrations, the vibrations become something in you, the word becomes you, you become the word, you are the law. And that is the power, the force.
Which is coming from where, Frank? Well,
it's coming from where people want it to come from. It's coming from the divine. And how do I prove that? I prove that by saying to each and every one of you that we are all part of the divine. I'm part of the divine. I have certain gifts. You have certain gifts. I've met and I've been honoured to meet people who have gifts of psychic clairvoyance. I have none of those. I'm as clairvoyant as a rock. But I have different gifts. Some people have the ability to write brilliant music. Brian is, overflowing with talent. And one of them is, his creative gifts of music and brilliance. And so we all have different talents. And there's a parable about that. It turns out that one of mine is that from a certain age, this has been like a thorn in your foot that just keeps aching until you finally address it. And it is that we all need and want and hope to stand up, but someone has to light the match. Well, Martin Luther lit a match, and he wasn't alone. I mean, a lot of people stood up. So I guess all I'm doing is lighting a match. But it's, want a better word, and I know the word is laden, but it's a job. But where does it come from? It comes from the divine. It comes from exactly the same source, and it is, and hopefully is, self-evident when people see it. Now, I will qualify one thing in that, and I've said this before. When you read One Heaven, and you read a number of sections, there are confronting aspects to it, not the least of which people will see when they see ecclesiastical law. Confronting, challenging. And it is easy for people to say, well, this is not divine. This can't be divine because, for example, they're talking about the end of hell, or they're talking about certain treaties, or they're talking here, they mention occasionally about demons and, angels, and that's all, never talk about that. Well, what the ruling elite get us to believe is that there is these two sides. They pretend to represent the good, and then they go off and they secretly worship the dark. And so long as they do that, we allow them to continue this torture where they promote a war in heaven and they promote a war on earth. And until the war in heaven ends, there can be no peace on earth. So all I say to you is that when you read, we grow, hopefully. We grow in our faith, and our faith is strengthened and not weakened. And I sent an email out the other day, and I said this the other day, one of the pronouncements of faith of anyone that has been brought up in believing the truth of the Gospels and the truth of the Bible is that at the end of days of evil, the dead shall rise. As a miracle, the dead shall rise. And I shared the understanding that in the reading of the covenant, when hell is ended, then there is something worse than being dead, and that is being in hell. So when hell is ended, the dead rise. And I also shared the idea that when you realise Sesta KV trusts have been put in place and that the existing system treats us as the living dead, and these cannons smash once and for all the Sesta KV as lies, then literally you are watching before your very eyes, and particularly when you sign and seal ecclesiastical deed poll and then walk to the bathroom and look in the mirror, you are looking at the risen dead, literally, the risen dead. Now, if that doesn't strengthen your faith and validate your faith and validate the source of this, then I don't know what can. So that's my answer.
Very good, Frank. Thank you. All right. Do we have any other questions? There are a couple of other folks that came on the phone line. I thought maybe you came on for asking a question or two. Brian, did you have anything else you wanted to add regarding some of the chat?
I think we've covered quite a lot, and again, we're going to cover the deed poll in a little bit more detail on the Sunday call that Frank's doing. Okay. So yeah, I'm fine with anything else you want to cover tonight. We can probably leave for us for another time.
Yep, we're approaching the top of the hour, Frank. Just turning 11 o'clock Eastern time. If we have no other questions, do you want to let everyone know when the next call will be?
Absolutely. Yes. There is a Sunday call by the invitation of Gary Ray, and if anyone is interested in that call, then we're more than happy to share the number for that talk show. And, of course, we will be doing the same on this talk show next Thursday. And all I ask is, in the interim, that I really do want to make this relevant, and I hopefully, as I've done tonight, hopefully answer questions that people have and help you in your learning. So please send those through so that we can make the topics and the subjects relevant to you. The other thing we'll do, so that we're not going back to the same issues over and over, what we're going to try and do is also next time is forward in